Jeff and Chris. Hope everyone's having a great day today. The truth is a hell of a lot. I was just reading an article from the Markup today, and it says that the global market for location data is around $12 billion. That's how much companies are paying to grab your location data and trade it and sell it, which is pretty damn amazing. So there's a lot of interesting things to be talked about with location data. I think it's obviously very sensitive personal information, and when you think about it, right? If you think about why, what, when, where, how, when you talk about the 5 whys, a lot of the time when we think about personal information, we're sort of talking about identity, but location is almost like sort of like a whole separate thing. Certainly it's part of personal data, but it's separate from identity and almost equally as valuable. And certainly when people know what your location is, they can figure out your identity in many cases, which is why so many marketers and other organizations want your location information. So it's incredibly valuable and it's incredibly sensitive, and that's what we're here to talk about today. Chris, you want to say hello?
Yeah, and I bet those 12 billion is just the official number. I wonder what the kind of gray market number is of PIs and whatnot that track people that don't even know that they're being tracked, where people just kind of put a device on your car. We should actually look up that market by itself, because you can you can buy these devices, right? And I mean, Apple to some extent also sells those. I'm still not convinced that was a good idea for them to create these little nuggets and let everybody buy them. Did you buy one of those? I forgot what they're called.
I'm not certain.
Those little tags that you can get.
Oh yeah, the Apple tags, the tracker tag.
Oh, that's what they're called. Yeah, I looked at that, picked one up, was about to buy it, and I'm like, oh hell no! It's like, no. It's just too creepy.
Don't think, I need any of those. I was going to buy some of the tile trackers to track my keys, and then I thought, I think that's probably not something that I need.
Yeah. The only thing that I keep losing is my remote.
Yeah. So Chris, we've got a couple of guests here that are going to talk. I know that Heidi has to leave, so I'm going to bring her on stage if we can get her up here. She was sort of been bouncing back and forth. Heidi, can you ask to come aboard? There you are.
Cheers.
And we'll let you have sort of the first talk. And then we've also got Odia Kagan, who's here to talk with us a bit later, and other folks as well. Anita is also here as well. So we got multiple speakers, but we're going to start with Heidi today. Heidi, you want to introduce yourself and tell us your thoughts on location data?
Sure. Can you hear me? My LinkedIn's having trouble loading this thing. Are we good?
Yeah, I think we're good.
All right, cool. And you're recording it because I want to hear what Odia has to say too, but I got to jump soon, right? Yeah, awesome. Well, my name's Heidi Sass, and I'm a data privacy and technology attorney. I live outside Washington, D.C., and I work on privacy issues as part of consumer rights. So when I hear about location data, it is more to me than just privacy. It's a safety issue. There are two examples of scary things I've seen, not in the too distant past. One was a debt collector. And whenever they would sign you up to start paying on your debts, they would send you email nudges. And as soon as you would open the email, it sent location data. So they were also sharing that with the repo man. So that's a frightening aspect. And, there's a lot of data coming out of cars anyway, but do they also need your phone? So there's behavioral information. Are you at work? Those sorts of things. It's just information they shouldn't have access to. And the other one are the air tags. Because as soon as they came out, my first thought was intimate partner violence, and sure enough, it spiked. And they can put it in the back of the car and you don't hear it chirping, and sure enough, you turn around and there is your stalker. So location data, I think, is the most personal kind of data because it relates to safety. It's beyond privacy. So the sooner we can do something about this, the better.
Yeah, yeah. I really agree with that. That's really important information, Heidi. There's a podcast set of episodes that were put out. Now I'm sort of blanking on it. It's called Nowhere to Hide. Was the series put out by shit? Sorry, I'm blanking on it now. I'll follow it up with our fact checker, and we'll get that information out. But it's really good and talks about exactly that kind of location privacy.
Yeah, I think the BBC was doing a series on that as well to talk to some of the victims and to hear the human side of the story just to get more impact. So I had an interesting call earlier today with some legislative and lobbyists and policy activists in California. And they are moving forward with something similar to the Delete Act that might be, something that we try to advance and work on a little bit. But also there are other initiatives, and we're getting a speaking event together in June about data brokers and what they do and why, it's a problem. And then the different ways that we can go about addressing it. So it was exciting to hear that lawmakers and privacy advocates are working together on these issues in California, if nowhere else. So that's the latest news that I got.
Yeah, maybe to throw one example in there, what's very relevant. So one of the organizations that we are supporting kind of with knowledge and technical expertise is a NGO called Ideas Beyond Borders. And so what they do is they facilitate the transfer of value and information to people that live under authoritarian governments. And one morning when I talked to the president over there, he said, "Chris, you won't believe it. We got a call yesterday from the FBI, and they just arrested two, in this case it was 2 or 3 Iraqis. They came to get one of the dissidents that they got out of Iraq. They wanted to capture him and take him back." And so you can imagine that if you have kind of consumer grade solutions out there that make tracking of these individuals really easy, that's like a step further, because these people are being captured to be disappeared forever, and that's really, really scary.
Yeah, it's safety rights.
Yes.
Yeah, absolutely. I agree. I'm glad to see so many people are getting involved.
Yeah, finally, it's been some time. I mean, that's part of the reason why we do this particular show, and we're going to put it on kind of a wider audience. So we're still experimenting with the format, but that's exactly what we need to create more awareness for, I think, and make people sensitive to. And then,
hey, Chris, you know a lot of famous people, right? Do you know will.i.am? Do you know how to get a hold of that guy? Because he would be great as a speaker for the Data Broker event. Like, you're in California. You know everybody out there, right?
I'm probably 2 degrees removed. Yeah, I know a few people in Hollywood. Yeah, ping me and we'll try to make a connection.
Yeah, man, if you don't ask, you don't get. So I'm going to ask.
Sure.
Let's do it. Let's make it happen. Awesome.
Yeah.
Nice.
And on that kind of in a similar note, so we're doing a very large CBDC event. I mean, same topic here. This could end up being kind of surveillance coins, and a lot of people are concerned about that. So at that event on May 12th, we have a congressman who agrees with that notion, and people from the IMF, Fed, and Keto, and Milken. And it's the same thinking, right? We should not create solutions for the world that allow the permanent tracking of anybody. It doesn't matter if it's physical or digital. I don't differentiate. Right?
Yeah. I agree with that. Well, I got to run, but I'm glad
Sure.
you're recording this so I can listen to all the stuff that happens next. But
Yeah.
So I thought I'd just throw those bombs in there and then take off. But thank you.
Yeah. Shall we bring on audio?
Yeah. Thanks, Heidi. One note before we do that. So the podcast that I was mentioning is a podcast that's actually on hiatus called So Bob, and it's by Bob Sullivan and a co-host whose name I can't remember, but they have a series within that podcast called Nowhere to Hide, and it is really awesome, especially for privacy folks or people that are interested in privacy advocacy. very highly recommended. So check that out if you can. Odia, if you want to request to come on stage, I'll bring you up, and you can introduce yourself and tell us all about hopefully this new class action lawsuit, as well as whatever else you could tell us about location privacy, which I'm sure is a hell of a lot. So welcome aboard. You probably have to unmute yourself. This interface is a little bit strange.
Oh, there we go. Can you guys hear me?
Yes.
Okay, LinkedIn was giving me some pop-up that about my microphone that I didn't realize was there, and I was like, why is this not unmuting? Okay, well, great. Hello.
Great to see you, Odia.
Nice to be here. Thank you for inviting me.
So yeah, what can you tell us about this class action lawsuit? I saw your post. I read some of the actual legal brief, but you're definitely more qualified to summarize that for us.
So I think that this highlights, really, I think we can use it as a springboard to basically to do a discussion about this topic. So the class action lawsuit specifically actually calls out a specific law in California, the California Invasion of Privacy Act, pursuant to which it is not legal to use something called an electronic tracking device to determine the location or movement of a person without consent. And an electronic tracking device is a device that's attached to a vehicle or movable thing that reveals its location or movement by the transmission of electronic signals. So this is a really specific law that was flagged here as breached. I think that there are similar laws in a couple of other states. I think Texas is one of them. But this is so this is a really, let's say, specific use case, and people are thinking, well, how am I supposed to know about this particular issue? But I think if we talk about this concept, let's talk about the use case generally and what the legal landscape looks like right now for this. So the first set of facts is that we're assuming for the purpose of discussion, and I think we're going to talk later about how this works, but let's assume for the purpose of discussion that this is personal information, right? Precise location information is personal information. It is sensitive personal information, and it is information that's notoriously difficult to anonymize. So obviously one of the questions that's going to be discussed in this class action is whether or not this information was anonymized or not. For the purpose of the discussion, let's assume we're talking about personal information. If you're collecting precise geolocation and not anonymizing it, what does that mean under the current legal regime? So the first thing is, we talked about the specific Ccpa law. Let's put that aside for a second. What other laws apply? First of all, Ccpa, CPRA. When you're collecting personal information under Ccpa, CPRA, you definitely need disclosure. You need a notice of collection. If this is information that you as a data broker are monetizing and sharing with third parties, you also need an opt-out of a sale, right? A notice and opt-out of a sale. The other piece is per the FTC, and this is actually something that I feel good about, having talked to clients about this, before CCPA and a long time ago. I said, guys, FTC 2012 paper and other papers said precise geolocation is sensitive information that requires consent. And the FTC has always thought that. And the FTC, I think, thought that even more after the flashlight app enforcement action. And actually, the flashlight app enforcement action, some of you may know, actually made its way into the California regs, right? And there is a specific reg in CCPA that says if you are collecting location through your mobile app and you are using it for a purpose which is not expected by the user, you need a pop-up notice, a just-in-time notice. And so this is specifically with respect to mobile apps, but this is, the FTC hovering over saying, hey, precise geolocation, right? The other piece is under the Virginia law, the CDPA, precise geolocation is sensitive information, and you need opt-in consent, and you need a DPIA. You need a data protection impact assessment or a data protection assessment, or every law says it differently. And actually, under the new impending, right, Connecticut law, which I think we're calling CTDPA, I don't know, we've exhausted all the C's and the P's and laws forever. They actually have a specific treatment for precise geolocation. Precise geolocation is sensitive information. Precise geolocation requires an opt-in consent and a data protection assessment. And there's actually specific treatment of precise geolocation or location information when used in the context of profiling. So automated processing performed to evaluate location or movement is profiling and subject to the treatment of profiling in the law. So that's really interesting. And then the other piece is the Association of Auto Innovators, right? The Association of the OEMs in North America published privacy guidelines, I think in 2014, if I'm not mistaken. And under those guidelines, when you collect precise geolocation or share it, number one, you need notice. Number two, if you are planning to use this for marketing or share it with third parties for their own purposes, you need consent. And so basically, I think what we can, and I can wrap it up and see, and obviously take questions. But basically, the bottom line here is, if you're collecting precise geolocation, number one, you need notice. Definitely under 7 different things here. Number two, you need this notice to be notice at collection, just because, California says notice at collection and everybody says at or before the time the data is collected. So you need a notice at collection. You need consent in a lot of the cases. And even if you don't need consent, I think the difference between where are you putting this notice, right? This notice needs to appear somewhere and maybe get clicked away or not. So people definitely need to be made aware of it. And the other piece is, come 2023, you will need a data protection assessment for it. And even now, the other point that I want to make is we're seeing a big uptick in the emphasis on data minimization. We had in the US, we had an enforcement action by the FTC, Cafe Press, that regarded the failure of data minimization as an Article 5 FTC Act violation. And we saw today a guidance document from the FTC with respect to COVID data that specifically talks about data minimization. So that, coupled with the fact that CPRA and CDPA and the other laws require some sort of data minimization, also is something that tells me that when you're dealing with precise geolocation, you need to do an ex ante and before the fact analysis of why am I collecting this? Do I really need this? Do I need precise geolocation? Can I not do precise geolocation? Can I round up some, decimal points and have it not be precise? Do I need it real time? Can I do it incrementally? Do this data minimization analysis at the start, and then of course notice and consent.
That is awesome, Odia. Love the analysis. Can you tell us more about the data minimization piece?
So data minimization is obviously this one. It's, I think, one of the privacy principles, something that is highlighted in GDPR Article 3, and we have this sort of phrase of necessary and proper, or necessary and relevant, or proportionate, or adequate. And that's a lot of really vague words that nobody really understands what they mean. So what does that mean? Let's say in the context of geolocation, let's apply, right? Let's apply the rules, right? So the first rule is only collect what is necessary for the purpose. So what does that mean? The first thing is you need to know what the purpose is. Right? And the FTC now and the guidance today from the COVID-19, they're like, well, why are you collecting this COVID data? Do you need this for, what do you need this for? So first of all, what do I need this for? And when you do this analysis, I've been doing with clients in the automotive space, I'm like, do you need precise geolocation? Well, we need it for X. I'm like, can you accomplish X without precise geolocation? Can we do something, less specific and get the same thing accomplished? So the first thing is really closely define the purpose, which is really, fortuitous because all of the new laws require purpose limitation. So you need to know your purpose and list it and, not use it for any other purpose. So that's great. Then you need to make sure that the data that you're collecting, i.e. in this situation, right, precise geolocation, is relevant and helpful to accomplish the purpose. So if you can ping a location every 15 minutes or hour or whatever, that would be better than doing it in real time. If you can do it to a 500 meter square or 1,850 feet radius, that would be better than precise geolocation. And this is the same criteria, which is like, do you actually need this for your purpose? And do you really need all of it? Like, do you need the precise geolocation aspect of it? And then you need to figure out a process to tell people about this, right? The purpose. So we need the notice of collection, the pop-up notice, the sticker in the car that says, hey, we are tracking your location. However you want to do it, you need to figure out a way that people actually will know. And then the second piece is you need to retain it only for as long as necessary for the purpose. And this is really important with respect to geolocation data, which is very sensitive. And therefore, if it gets implicated and people get re-identified, then that's a problem, right? So we saw in the context of precise geolocation collected through mobile apps, right? Not vehicles, but mobile apps. There was an article, I think, in Vice a few days ago with respect to a provider that was basically kind of tracking people going from like the NSA headquarters to like the CIA headquarters or something. So like that, or the Catholic Church clergy person who was outed through like information like shared through Grindr and other apps. So this is very sensitive information. Therefore, you need to figure out with your stakeholders, how long do you need to keep the data for the stated purpose? How long do you actually need it for? FTC and Cafe Press said that. FTC and the COVID-19 guidance said that, hey guys, you've been taking temperatures and COVID vaccines. Do you still need status or IDs scanned? Or do you still need that now? Can you like kill it? So figure out what the term is. Figure out if you have any data retention laws that would apply and require you to retain this information. And then figure out, okay, I have some data retention laws that apply to me. Do they apply to everything that I'm collecting? Do they actually apply to the geolocation, precise geolocation, or do they just apply generally and I can kill the geolocation, I can obfuscate the geolocation? Because the guidance in this area has said it's not enough that you have a retention period and abide by it. It's got to be granular. So if you have a database with 10 things and the law requires you to retain one, you got to delete the other 9. And the other thing that you need to do, 2 more things, is one, having said that, having made this retention period, reassess it, right? Like I think a year's enough, and then after 1 year you're like, well, maybe a year's too much. So reassess your decision kind of periodically. And the last thing is like delete it like you mean it, right? So delete means delete. Delete doesn't mean I'm going to move it to some database, that is not active. Delete doesn't mean I'm going to, delete the first name, last name rubric, but actually leave the entire, kind of Google Maps like trip that has there, which as we know, right, can be easily re-identified, right? If you delete it, you either really delete it or you really, really identify it. And that is, as with respect to precise geolocation and real-time information, query whether, how and whether you can actually anonymize it. But anonymize is a pretty high standard, and you've got to meet it in order to meet with the requirements for data minimization.
Yeah, ultimately, most data shouldn't be created in the first place, in my humble opinion, because data deletion, anything that's digital to delete it is really, really hard, right? Because a lot of systems, specifically in these large scale operations, have multiple backups, multiple sites, and it would be very hard for them to go through those retroactively and actually remove them, then even maybe overwrite the hard drive so you can't restore it and so forth. So That's why I usually maintain the position that this kind of right to be forgotten is kind of quaint in terms of a technologist's perspective, because it should really be by default that you're not being observed, right, as a requirement. And that's, I think, is an important mind shift that we need to get across to regulators overall, that you're talking about something that's technically not really feasible or can't really be done with the existing systems. We really need at some point in time soon cryptographic primitives that are mapped to the owner. And I would actually go so far in saying that certain data should actually never be entered into databases and should have never been entered into databases. But Jeff, you wanted to say something. Yeah.
And one thing is, there's a guidance out of Bavaria with respect to the Apple Lookaround service, which is kind of similar to the Google Street View. I think maybe different purposes, but for the purpose of the data collection, it's similar. And they go through an analysis of what you need, which obviously you need a notice, you need opt-out, but they also take into consideration the specific data minimization pieces that have already been incorporated by Apple, namely that the information is pixelated at the start and it resides in the vehicle and it is transferred inside, encrypted. And this whole concept of like certain things that reside in the vehicle and are not shared out, but rather very specific things get shared out. That is also in the EDPB guidelines on connected vehicles. They also say that. They're like, well, do you need to collect it? Okay, if you need to collect it, do you really need to share all of it with, I don't know, whatever, the pay as you drive insurance provider or whomever, or can you store this in the car where you control it and you don't share it with third parties unless you really, really need to?
Right. I think we need to talk for a moment about the de-identification, the anonymization of this data, which you brought up, Odia, as well. From the information I've seen, and I've studied this quite a bit, if I get 4 precise spatio-temporal geolocation data points on you, Odia, I can figure out exactly who you are with a 95% certainty, right? So all I really need is 4 data points if they're precise geolocation, and I have a timestamp on them as well. So that's pretty chilling, right? When people say that they can anonymize this data, and we know for a fact that the data researchers say that they can pretty much identify any American with 4 location points.
Yeah, I mean, I've read the same thing, and I think I've read, not only have I read the same thing on the research, but we've seen, right? Like we keep seeing these, scary articles on some data broker offering, they have billions of points of data, and they're able to geofence somewhere and figure out, who this person is, because this is where they go in the morning and this is where they go in the afternoon. And then, find out their identity. So yes, definitely. I mean, I've seen it from like the sort of funny aspect where people, I'm sure you have, this has also happened to you, people saying, during 2020 and 2021, looking at their Google Maps history and saying, oh, thanks Google for telling me I didn't go anywhere. But now, Google is telling you you are going somewhere, and also everybody else knows where you're going, right? So yeah, it's definitely, it's notoriously difficult to de-identify, anonymize this type of information, and that's what makes it so problematic.
Yeah, absolutely. When I was researching this information for this show, one of the things that I ran across was a data breach that I was unaware of. Maybe you've heard about it. There was a service provider, sort of a supply chain provider called Cineverse. They still exist, right? But they're a backbone provider for wireless carriers like AT&T and Verizon, T-Mobile, actually all of those, and a lot of international telecoms as well. And they process 740 billion text messages every year. And last year they reported that for the 5 previous years, they had somebody in their system apparently watching all those text messages. And
Well, that's fun. I mean, that's not location. I mean, you could derive location off of it, I guess, but that's also an issue. At one point, I guess, that I didn't mention about the class action we were talking about, which is the other piece that factors into geolocation, or generally, data which is taken out of vehicles or mobile devices, is whether or not this information is intercepted in real time. Because if it is intercepted in real time, then we have a whole, the whole lovely making a comeback world of wiretapping laws, right? It's not, it's not your mother's wiretapping law, right? Like, it's not the phone call anymore. It's other things. It's real-time interception of communications. And we've seen actually some class actions about this, even in the context of vehicles, with respect to service providers, like intercepting and cloning text messages and sharing them. And so that's another issue. It's a separate issue, which is number one, this interception of the communication. And of course, wiretapping laws are, again, in the US, despite, we don't have a federal privacy law, blah, blah. But wiretapping laws, a lot of them require consent. They're a to consent type thing. And the person being intercepted needs to know about it. And so that's also something to think about, is how do you do that and get that pop up consent that you need to get.
Yeah, absolutely. Yeah. Well, I think these text messages may have some sort of geolocation on them in this particular this data breach, but I'm still trying to find more information. It seems to have sort of got pushed under the rug for whatever reason, but I don't know. It seems pretty crazy. So I'll probably try to do a post on it later if I can find it.
I mean, it makes sense, because you travel everywhere, and you get these text messages. I mean, I get text messages from my mobile carrier. It's like, welcome to Germany, welcome to whatever. I was in Israel a few weeks ago, and I got a welcome to Jordan. I was not in Jordan, but I was close enough that I got a welcome to Jordan. So it is obviously picks up, the cell towers and things like that of where your phone is.
Yeah, absolutely. So,
Yeah, maybe as an interesting, Jeff, maybe as an interesting anecdote. So we are very interested from a funds perspective to make investments in solutions that replace the current credit rating systems. And so one very interesting startup that we looked at in Africa, what they did is they used the location data to determine the creditworthiness. And I'm dumbing it down massively, but if you are a person that goes to the same location at the same particular time, stays there for whatever particular time, and then comes back, they can draw particular conclusions out of that. I mean, the obvious one would be, okay, this is a person that shows up to work every day on time, goes to a particular location, spends their time there, and I can also then maybe deduce that this is an office location and not a bar. So it could be helpful in these particular cases, specifically for people that we are talking about people that don't have government issued credentials. So for them to base a credit score based on this particular behavior is helpful. But yeah, on the flip side, you obviously can use it for nefarious reasons as well.
yeah, that's interesting, Chris.
And so while we were talking, I was just pulling up our office building here. So I noticed that on Google Street Maps. So the last time apparently that my car was spotted here or was live taken was 2022 or not 2020 in December. So I see my car there, my partner's car there. And I'm wondering, because all the license plates are blurred out, if that's a feature that's built into the camera itself. I assume not. As in, they probably remove that later in processing.
It's required. So I think it's this is this guidance. So the guidance for the Apple look around is based on this guidance in Germany for Google Street View. So they have the same requirement, which is you've got to pixelate faces, you've got to pixelate license plates, You've got to notify people that this is happening. Like, query how you do that. Do you put it on the vehicle? Do you put it in like newspapers for the neighborhood? Do you put it in street signs? Obviously, you have to mark the vehicle as it's like riding around taking photos of people. And then you also need to let people object and have their information removed. And interestingly, even though I think that's like a Germany specific issue, whereas in the US, I don't know if that works, but you actually in Germany are allowed to object to the non-pixelated appearance of the facade of your house, because that's, I don't know if it's because it's identifiable or it's because of a copyright issue or something, but in any event, you are allowed to also request that your building be blurred as well or removed or something.
Yeah, I only have like outdated data here that goes back more than 10 years, but even back in 2010, already 250,000 Germans or German households, it says, opted out of Google Street View. So there's an opt-out function.
Yep. I think the original Google Street View decision was actually 2010.
Yeah.
I think that was the original one.
Interesting. Do we have any questions from the audience for Odia? I mean, I've got plenty of more questions, but I want to let the audience ask questions as well if anyone has anything. I also thought we could go ahead and bring Anita. Am I pronouncing that right? Name right, Bose? Ms. Bose up on stage as well. To just go ahead and join us if you want to raise your hand and ask to speak. I'm probably butchering your name.
She got it.
Hello.
Hey, how are you?
Hi, Jeff. How are you? It's Anandita.
Sorry.
That's okay. That's all right. Thank you so much for including me. It's been so pleasant hearing from Heidi and from Odia. I hope I'm saying your name correctly as well. Please let me know if I'm not.
No, that was good.
It's just, yeah, this case, and especially the autonomo piece and fiasco, for lack of a better word, it's just caused so much of a headache. And I remember reading about the case earlier on, and then Jeff, when you put the post up, I just got I couldn't help but get so riled up. I'm like, oh my gosh, like you mentioned, here's another situation of this company yet again not meeting the standards, not putting the appropriate protections in place. And I just found it so ironic. Like, all they have really in their terms and conditions is, oh, please, pretty please, don't unmask the identities of these people and the data. And it just really begs the question in my mind, is it ever truly possible to protect the data and make it, fully de-anonymized and yet still have it be useful?
That's a good point that you raised there, right? I mean, is that anything worthwhile to actually just say to somebody, hey, we've anonymized this data, you're not supposed to unanonymize it, especially when you've got companies out there whose sole business model is to unanonymize data, to re-identify it, right?
So I think it's both. I think it's a couple of things. The one thing, so this is an interesting issue, and I think by the way, for this, I think probably it's worthwhile saying that this is just a complaint, and that we don't know how this is going to shake out, and especially with respect to the anonymization question. So we're talking about the issues generally, but the issue of the anonymization, de-identification, here's the interesting thing that's happening. There is a definition of anonymization under GDPR, and under GDPR, the definition is you got to make it so that you cannot go back to the person ever. And then you have guidelines from the Article 29 Working Party, and then you have guidelines from more like tech savvy organizations and from NIST, and there's a lot of guidelines on how to do that. Then come the new privacy laws in the US, and they actually require you to go through certain steps in order to reach this threshold of de-identify. And those steps are not only taking the tech tech steps, which I mean, we have yet to see how this shakes out, but I would assume that the tech aspect would parallel the GDPR piece, right? Like take the tech steps necessary in order for this to not be able to be re-identified. But then you also are required to, number one, have policies and procedures that prohibit the re-identification. And number two, have contractual requirements prohibiting the re-identification. So the fact that you have terms and conditions prohibiting the re-identification isn't a problem. It's actually a legal requirement in the US. But the query is, right, where and how do you also attain the tech requirement for it to not be re-identified? And and the problem here is, besides the fact that we said that this data is difficult to de-identify specifically, but the problem is with the ever-developing technology and the ever-increasing additional databases and data that is being poured into the universe, right? That you can cross-reference. Then you then have other means of re-identifying. And the Article 29 Working Party said, you've got, when you make a decision on whether or not you've anonymized, that decision is nice for, April 29th, 2022, but it may not be correct for July 22, and it may not be correct for January 23, because you got to take into consideration the changes in technology, the means available out there. So it's really a complicated issue.
Yeah, that's insightful.
I do have one more question. So, Odia, when you mentioned that, including in the terms and condition, how do I say it? So it sounds like that it legally it passes, but like morally or ethically, is that robust enough to be something that would otherwise protect the data?
So we obviously haven't seen enforcement on it yet, but the way that the CCPA CRA draft it is they basically say you need, it's kind of like the same as technical, organizational, and contractual measures, right? So the technical measures are, we just talked about. The organizational are, you need to have policies and procedures that govern how you yourself, do it. And then the contractual is you need to contractually bind your downstream to do it. How do you do that? Well, I don't know, but I think the first, judging by other downstream binding precedent that we have, is at minimum you want to have an enforceable, a binding agreement, right, between you and your downstream. So you have the provisions in your agreement with your immediate whatever third party that you shared the data with. Are they a processor, sub-processor, service provider, whatever you call them, right? So let's say, tier one of the party you share with, you have a contractual obligation to not re-identify. Number two, you need to, and this is sort of standard practice already in, GDPR data processing agreements and CCPA data processing agreements, you need to require your downstream to be bound by the same obligations. So like your tier one needs to bind the 2 and the 3 and the 4, downstream not to re-identify. So I would say that's like, at minimum is number one, you bind yourself and you have policies and procedures to check this. You bind your immediate data sharing and then you bind them to do it downstream. Then what do you do ahead on top of this? That's an interesting question. Like, are you obligated to audit? Are you obligated to audit your tier one? Are you obligated to audit the tier 3 and 2 and 3 and whatever? That's a very interesting question that I don't think we have the answer to. And we are discussing this a lot right now in the context of, GDPR cross-border transfers. Like, what do you do with respect to your processors and sub-processors and sub-sub-processors and all of their supplemental measures? How do you actually do it? And is it enough to get a representation for them? My gut instinct is I think you should reserve the obligation to, not the obligation, reserve the right to audit them. And because we've seen that in FTC enforcement actions where the FTC has said, the fact that this is a contractual obligation on your provider is nice, but why didn't you check? And the check in that situation was as to your immediate service provider. So I think that's my gut reaction would be, reserve the right to audit and then go from there.
I completely agree with you. Just to give you a little bit of background. So I come from like the public health sector. And I work for the cybersecurity team, and the auditing portion is something that's already exist in cybersecurity, especially for vendor management access and what have you. So the fact that that's now being considered at length and depth in the privacy field as well is something that is really refreshing. So good to
Yeah,
hear.
because you guys are ahead of us. You guys were doing it back when there were non-regulated entities in the U.S. that were just subject to FTC enforcement, right? So now we're all regulated entities.
Well, here in Canada, we have our good days and bad days.
Even though I think that Quebec 64 has a data minimization requirement and a bunch of other things. So you guys are catching up.
Well, Quebec passed a pretty an updated privacy law that's much more, I would say, in line with new technologies, how things are flowing in terms of trends and issues. So we'll see. I'm in Ontario, which is a different province, so we'll see how things happen. If the entire federal law gets updated, we'll see. Fingers crossed.
I know you've been trying, but then
Yes.
and then I saw this article that said adequacy, who cares, and let's not do anything.
Yes.
Hey, what can we say about IP address? Anybody want to comment on that? Obviously, there have been a few DPA decisions and some back and forth there. A lot of U.S. laws don't really address IP address as location data, and I think that's a bit of a hole in some of our thinking there. Any comments?
Many. I mean, that's a topic that we've been talking about for, I don't know, almost 30 years at this point in time. So originally it was actually that whoever provided you with your internet access would also then assign an internet address to you. And so in that particular case, even I might be in San Diego, I might get an address that was originally assigned to a data center in Texas. And so honestly, by and large, that location data that was associated to the first range wasn't very accurate, wasn't very useful, was very salted. But ultimately, now that you are tethered to your mobile device, that is actually much, much easier, because now you can supplement it with triangled data from different cell towers or even from GPS. And it used to be, actually, from a technical perspective, that might be too nerdy for most people to know and want to know, but that these were different chips as far as the GPS and the actual CDMA or TDMA chip. The actual cell chip, they are now one and the same. Qualcomm here in the United States actually made it into one chip for just, I think, efficiency reasons. A larger point there being, though, is there is other providers that have much better location data. So the military has GPS data that gets you clear data down to like 2 centimeters, I believe. But there you actually have to, what's interesting, you have to have particular licenses to even buy these chips. And now that's essentially entirely avoided by the fact that we have consumer grade things that are most of the time actually better than what the military has. Anyway, a little bit of technical background. Actually, a friend of mine owns a data radio factory. They make these kind of nerdy, very nerdy advanced technologies. But yeah,
I can add the legal nerdy part of this, which is IP addresses have, for a long time, it's actually also a German case, Breyer, on IP addresses. They've for a long time been fully recognized as personal data under GDPR. They are literally listed in CCPA in the list of what constitutes personal information as part of personal information. So IP addresses are personal information. Then there was in the history of CCPA, there was like back and forth from industry trying to push through regs that I think got passed and then got scrapped with respect to, it's only personal data if you are meaning to use it in order to identify the person, and then they got killed. And in the meantime, we have a lot of cases out of Europe, specifically in the Google Analytics context, that are talking about the fact that okay, first of all, IP address is definitely personal information, but you can also have personal information without the IP address when the IP address is redacted, depending on what else you're collecting. So the fact, and also the fact that the IP address, this is something that clients have often told me. It's like, we don't know who this is. I'm like, yeah, but you're pushing advertisements to their screen. So you know enough of who they are in order to push the advertisement to their screen. That's enough. That's, when you look at the standards in GDPR for anonymization, right? One of the standards is linkability. Can you link it to a person? Okay, you don't know it's Odia. It's a person that Google's like cosmetics and perfume all the time. So you push cosmetics, hypothetically, of course, right? And you push this stuff to their screen, and that's identifiable enough.
Interesting. Yeah.
Yeah, I think ultimately we need to go like both up and downstream. And as far as I'm concerned, even like your phone number, not like in the past where everybody could have access to that. There was a published phone directory. I don't think we have this by and large anymore. But that should also be your private personal property and should be treated in that same way. That's why I often use this example of the do not call list for all your data, right? That's what I'm really striving for. And then another somewhat more anecdotal example is if people haven't read the book Demon by Daniel Suarez, he has a chapter in there. It's a hard sci-fi book written in 2009, 2010. But it has this one scene that depicts what we are talking about really, really well, Jeff. You probably remember that, where there's a person that is forging a ring that interacts with this kind of what we now refer to as the metaverse, quote unquote, that makes you invisible in the metaverse, but in the perspective of the augmented reality layer. And the purpose there was specifically to evade location detection, but then also be invisible to actual CCTV cameras. And that's really what we need. So, Jeff, we probably should get Daniel on our show sometime because he has been given this topic a lot of thought for more than a decade.
That's a good idea. I like that. Hey, we're running out of time here. Is there anybody else in the audience that has a perspective on location privacy that wants to talk, that wants to come on board? Or anything else from either of you two here on stage? What else do you want to tell us about location privacy?
I just wanted to, I guess, add or ask, the audience members that are listening, or Odia, for IP addresses. It's something else that I grapple with because it seems like certain legislation, whether that's in the United States or elsewhere, either call out IP addresses or not. Like, for example, the California Consumer Privacy Act mentions IP addresses, but they kind of have like the phrase that only if the identifier identifies, relates to, describes, and then they list on and on in terms of being associated with or could be reasonably linked to or directly or indirectly. So it kind of leaves the onus, it seems, to the organization or the company to decide almost whether or not IP addresses is considered personal information, right? And I kind of find that to be vague, and it just seems then it creates a patchwork of certain companies and determining or thinking it is personal information based on how they're interpreting the law and based on how they themselves are then analyzing their processes and policies to that of nature. And then in other instances, situations where it's not considered personal information at all, and therefore it's not assigned the same level of data protection. And so, yeah, go on.
I mean, I can start the tee up and answer. So I think first a couple of things. One is this trend of putting the onus on companies to figure things out and figure out their obligations and do the right thing, as opposed to putting everything on the individuals with notice and consent is a trend that we're totally seeing in Europe, and the FTC is totally on board with. This has been a number of speeches and presentations out of the different commissioners, and I think most recently Lena Khan in the IAPP conference. So that's number one. So the fact that the companies are needing to think about this and figure out what it is that they're collecting, whether or not that's personal information, whether or not that's sensitive information, what is the purpose of using this information. I think that's the trend. That's what's happening. The other is, I think that in reality, right, there is no clear-cut answer to this. Why? So let's talk IP address. If this IP address is identifying, it's an IP address for like a private home or an office or whatever, a certain like Wi-Fi location that identifies that only like three, if you cross-reference this with like it's a coffee shop that somebody frequents from 8:10 to 8:20, like in the Hugh Grant movies or whatever, and you can associate it with a person, right? Then that would be personal information, right? So the definition of linked or reasonably linked or linkable, right? That's on the one hand really vague. I mean, on the one hand, it's sort of narrower than any IP address is personal data, but it's broader, it's fairly broad, right? Because reasonably linked or linkable is a situation where this IP address ties to something that you associate with a person. If you have IP addresses that talk about that are, just for, servers or like a digital asset or something, right? Then does that identify a person? Would that ever identify a person? Maybe not, right? Same thing with VINs, by the way. We were talking about location data and vehicles. So like VINs, right? Are they personal information? Sometimes they're tied to a person, and sometimes they sit in a lot in the, at the port, and they are not associated with a person, right? So I think the use case and the actual use and the purpose would impact whether or not something is personal information, and somebody needs to make that decision. And I feel like the party that's getting the benefit out of it and has the liability is a good idea for them to get that to do that analysis.
Yeah, I like that. Odia, this might be a bit of a zinger, but any thoughts on the definition of personal information in U.S. state data breach laws? They seem to be a bit antiquated in my reading. Yes, they are narrower than the definition, say, under GDPR, right? And they are narrower than the definition under PIPEDA. They take a different approach. One, they're older, I think, and they take a different approach. And the approach is that there is a smaller set of circumstances, and under those circumstances, you've got to notify of a breach. And so that's one. Two, they are changing. They are constantly being amended and adding certain more like modern aspects, like, modern forms of payment, modern like biometrics, things like that. And so fact number two is they are kind of inching along and advancing. And then I actually don't know, because I'm not, data breach expert. I actually don't know the answer to how this shakes out when you have, so I guess the US laws have a bottom up approach, right? A narrow set of information where you have an obligation to notify, as opposed to GDPR and PIPEDA, that they have a top-down approach, which is, okay, this applies to all data ever, but provided that you meet with a risk threshold and you do the risk analysis. Now, how does this shake out in the end? Is there more notification in Canada or in Europe when you go to analyze the data? Yes or no? That's interesting. And the other thing that you want to take into consideration, which is interesting, at least to me, is that in the US, once you notify the individual. So the default is in notifying the individuals, and you notify the authorities only when you hit a certain threshold of number of people. Whereas in Europe,
you need to notify the authority first, and the authority may never notify the individual. So like the downside to you for notifying is like you're being overly cautious. You're being a good citizen. Maybe you err on the side of notifying, whereas in the US, if you err on the side of notifying, you err on the side of a class action lawsuit. So maybe the narrowness also serves a purpose here.
That's a good point. Really good point. All right. Well, we're just about out of time. Any last minute thoughts from anyone? From Chris? What do you say? This has been really, really enlightening to me. Hopefully for the audience as well.
Yeah, we're gonna try to summarize a lot of this on our new website, ybyr.news, where we're trying to aggregate relevant news in the space, and then over time we'll try to make them more digestible for like this cross section of legal practitioners and engineers, because in my mind this is where the largest gap is right now, that those two groups are not talking to each other. And obviously we also need to include the legislators and politicians at large and regulators into this discussion and enlighten them what's possible. By and large, I think most people just don't understand how close we are to this kind of George Orwell 1984 scenario, which I've been afraid of since 2008. And I taught privacy law right out of law school many, many moons ago. That's over 20 years ago. And my job at the time was specifically to train call center agents in what information to disclose, what information they couldn't disclose. And these were call center agents that were working for our ISP at the time where you had these dial-up modems and they were metered by the minute. And needless to say, initially there were a lot of issues. We had like 180 people or so in that call center where let's say the wife would call in and say, my husband has been online last night for like 3 hours. Can you please tell me? This would be a frequent occurrence. Anyway, so this comes to mind like almost 25 years later now, and now it's pretty trivial to track this type of behavior with a lot of kind of consumer grade software. But yeah, anybody who has interesting topics that you guys want to suggest, just email Jeff or myself. If you want to come on or talk about something in particular, if you come across something in the news, send it to us and we'll discuss it on Fridays. We'll probably at some point in time find a different platform, and we're actually discussing making this a lot more professional. So if you're interested in that, participating in that, please let us know.
Absolutely. And a big thank you to our speakers, Ms. Bose, Ms. Kagan, Ms. Sass, and have a great weekend, everyone. Thanks for coming.
Thank you.
Take care, everybody.
Thank you.
Yes. Take care, everyone.
Take care.
Yeah.